Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions. Today, we have a fabulous webinar given by the expert attorney in construction lien and bond claim law, of course, contract law, Stephen Marso. He has over 20 years of experience, and today's webinar is contractual payment provisions. So without further ado, I'd like to introduce the fabulous Stephen.
Thank you, Ariella. Hi, everybody. My name is Steve Marso, and I'm an attorney with Whitfield Eddy here in Des Moines. And I think we have about 20 minutes on this topic of contractual payment provisions. And we've got some slides that you can follow along. And so let's get started. So Ariella, if you could go to the next slide and the next one. Okay, so we have 20 minutes, and the issue of contractual payment provisions is a large topic. You could spend hours going over various contract payment provisions that are relevant to everybody's construction projects, but I'm only going to select 3 and go over them and describe some lessons for everybody. And so if you can take away a couple things from this webinar to use on your projects, or if you're an attorney dealing with any disputes you have over this, I think that'll be a successful webinar. So let's go to the first provision I'm going to discuss. And the provision is in the AIA document, A201. And one of the advantages generally of using standard contract documents like the AIA is they're used regularly. Generally, people know what's in them, and so they're familiar with them and can easily work with them. One caveat to make sure is that when you're reviewing the contract documents that use AIA, always review the supplemental conditions where the owner can make changes to the standard form. So that's a caveat. Another thing is always remember to read your contract documents. If you're going to bid a project, pay particular attention to payment provisions, what your rights and obligations are, especially on public jobs where you can't negotiate the terms, because those can make a difference to you in the amount of your bid and whether you're going to bid a project or not. So the first provision here is section 9.5.1 in the A201 Article 9. And what this provision says is the architect can withhold a certificate of payment to the contractor. So how the process works is the contractor submits a pay application to the architect reviews it, and ultimately decides whether to issue a certificate, and if so, how much to the owner, which then triggers payment obligations by the owner. And so what this provision says is the architect can withhold that certificate either entirely or partially if, in the architect's opinion, and that's important because it's the architect who gets to decide, if the representations to the owner required by another section we're going to discuss can't be made. Now, typically how this works in practice is there's discussions between the architect and the contractor about the architect's concerns, and usually they come to some agreement saying, okay, we'll adjust the pay app down or request less payment on this item, and they come to essentially an agreement where both sides agree with the certification. But if that does not happen, this provision says that the architect is to certify the amount that it believes is owed, even if there's not agreement with the owner, or I'm sorry, with the contractor. So the important part of this is the architect is the one who has the authority on this issue. The contractor can attempt to come to an agreement, but even if there's no agreement with the contractor, the architect's the one who's driving this. So at the end, you'll see the certification relates to these 8 specified reasons that the architect can withhold certifications. Let's go to the next slide. And the first reason that the architect can use to withhold certification is if representations to the owner required by section 9.4.2 cannot be made. Now, what does that provision say? Well, here on the slide, it says that that based on the architect's evaluation of the work and the pay app, that the work has progressed to the point indicated. So again, is the work progressing timely? And so that points to, where you have to identify in your pay app the percent of a specific area of work that's completed. So if you have 50% in your pay app and the architect says, I don't think it's 50% completed, well, then that percentage is going to get reduced. So if the architect's not going to agree with you on the percent complete, that can be a basis to withhold the certification or at least reduce the amount you requested. The next one is the quality of the work. So if the work's defective in whole or in part, and you've requested 50% completion for it, the architect could withhold certification on that entire line item if the architect's position is that work's defective and needs to be torn out and redone. And then finally, that the contractor is entitled to payment. That can encompass a lot of different issues, and we're going to get to that in the next slide. But the point of this is it's a very broad power to the architect on whether the work's progressing timely and that the work is not defective. And so if either one of those isn't met, the architect has the authority to withhold certification. Let's go to the next slide. So we've looked at the first of the 8 reasons. Now here's the other 7. And again, they're pretty broad. The first one is defective work not remedied. That's self-explanatory. The second one is an important one for a contractor because it allows the architect to withhold certification if there's third-party claims filed or reasonable evidence indicating probable filing. And so, for example, if a subcontractor calls up the architect or owner and says, hey, I'm not being paid, that could trigger this reasonable evidence of filing of claims. And I know I've dealt with a lot of these type of situations for contractor clients where a subcontractor is complaining about not being paid and the owner's making inquiries and the architect's making inquiries about, hey, can you show us evidence that you're paying these people? The third one is similar, failure to make payments properly to subs. Now, this one often triggers the need to send to the architect or owner the subcontractor, at least a part of it for a subcontractor, if you have a conditional payment clause in it. We're going to get to that topic in more detail later, but the point is, are you making the payments properly? And that depends on whether the subcontract requires the payment. The next one, reasonable evidence the work can't be completed for the unpaid portion or unpaid balance of the contract sum. 5, damage to the owner. Reasonable, and next one, reasonable evidence the work will not be completed within the contract time, and then finally repeated failure to carry out the work. So as you can see, these 8 reasons give the architect broad authority to withhold certification in whole or in part. And so it's important to make sure you understand that going into a project like this and do what you can as a contractor to address these issues when they come up. And if you go to the next slide. And the lesson, I guess, from this is the architect has what I call a limited power of the purse to police the contractor's performance. So they use that to leverage to make sure the contractor is performing the work timely and in a quality way. And so the lesson to contractors, do your best to make architects happy. And by that, oftentimes, or I shouldn't say often, but I know I've dealt with situations where there's relatively minor disputes, punch list often issues that can be frustrating to contractors. My advice is generally, address those issues because the ultimate decision maker on whether you're going to get paid is the architect, and so you want to do your best to make sure to satisfy them. Okay, so that's the first provision. So the next one I alluded to earlier are conditional payment clauses. And these are very important to contractors and subcontractors. There's two main types: pay when paid clauses and pay if paid clauses, and they're different, but they're both within the umbrella of conditional payment clauses. The first one, the pay when paid clause, it suspends a payment obligation downstream, for example, to a subcontractor for a reasonable period of time to allow receipt of payment from an upstream entity like the owner. So a contractor would use this pay when paid clause in their subcontract to simply delay payment for a reasonable period of time until they've received payment from the owner. I contrast that with a pay if paid clause, which transfers the entire risk of non-payment to a subcontractor. And so a contractor would utilize that clause to transfer to a subcontractor the entire risk of an owner's non-payment. So those are the two main clauses you see. If we go to the next slide. What do courts say about this? Well, most states, now again, it depends on what state you're in. Some states have laws that make these provisions void or unenforceable. Iowa is not one of those, although if you take a look at Iowa Code Chapter 573, which governs public projects in Iowa, there is a prompt payment provision in Section 573.12 regarding payments to subs. It's unclear whether that statute would void a pay if paid clause. There's no Iowa appellate court case on it, but just be aware of that. If you're on a public job in Iowa, there is that open issue here. But most courts, absent some statute that says otherwise, take the position that a pay if paid clause is enforceable, but they're generally disfavored. So what does that mean? Well, if you have a dispute over this in court on whether a provision is a pay if paid or pay when paid, courts will construe it as a pay if paid clause only if there's no ambiguity. So what that means is the language has to be clear that the entire risk of non-payment is being shifted to the sub. Any ambiguity on that, the courts generally will construe it as a pay when paid clause. So if we go to the next slide. So the lesson, if you want a pay if paid clause as a contractor, you need to use clear and unambiguous language. And I would suggest using what I call magic words, specifically say in the clause that the entire risk of non-payment by the owner is shifted to the subcontractor. Make it clear. And if you do that, then at least you won't get into this issue of whether it's a pay when paid clause or pay if paid. Now, if you're a contractor, you want a pay if paid clause in your subcontract, if you can. But if you're a subcontractor, you do not want those. So what's the compromise here? My suggestion, if you're negotiating a subcontract on this issue, use a pay when paid clause, but include in that the sub is not entitled to any payment if the amount being withheld by the owner is because of the subcontractor. So for example, if an owner is withholding $100,000 and $50,000 of that is because of a specific sub, then the contractor can withhold that essentially $50,000. But in another example, if none of that $100,000 is because of a given sub's fault, even though their work is included in that pay app, then you'd have to pay that sub regardless if you're a contractor. So that's a suggested compromise on this. Okay, I think we're ready for the next slide. Okay, the last of the three provisions I'm going to discuss are payment claims. And these are important for what I'll call payment disputes or extra work disputes. So not so much for the regular, scope work that you normally do and send your pay apps in that we just discussed, but for extra work, if a contractor believes certain work is outside its scope, it wants extra payment, you're gonna have to pay attention to the payment claim provision, and they're very important. So again, I'm going to go to the AIA document, A201 section Article 15, and specifically section 15.1.1, and it defines a claim, capitalized claim. So you see that there, and the important takeaway from this is a claim is not only a demand or assertion for extra money, but also extra time. I've found that a lot of contractors don't realize that time claims are subject to this. And that can be important if you're dealing with liquidated damages or delay damages by an owner, and you think you're entitled to extra time, you need to make a claim for that. So keep that in mind. We go to the next slide. And this is what I call typically the main provision for these claims that you see in the AIA. Now, keep in mind, as I mentioned at the beginning, you need to take a look at the supplementary conditions in your contract documents, because the owner can make changes. And one of the areas that often owners will make changes to this A201 is on these claims. And so you want to pay particular attention to what those changes are. But this standard form one we're looking at here says claims by either owner or contractor. And the important point there is owner is subject to this too. So not just the contractor, but the owner. So if the owner believes it's entitled to damages or some claim against the contractor, then it is subject to these claims provisions. But the other important point is the written notice has to be made within 21 days after the event that gives rise to the claim, or within 21 days when the claimant first recognizes it, whichever is later. So that's a pretty tight deadline. One of the changes owners often make is they reduce that notice time period, sometimes down to 7 days. So keep that in mind, because if you miss that deadline, that can potentially result in a claim being denied. Now, the other point of this is the claim has to go to the initial decision maker, which typically is the architect, with a copy to the owner. So you don't want to send it just to the owner if you're the contractor. You want to send it to both the owner and the architect. And owner, if you're making a claim, you want to send it to the architect and the contractor. Now, one caveat, I don't have a slide on this, but under the A201 2017 version, the AIA expressly excluded from a claim any owner claim for LDs, for liquidated damages. And so that's a big change, because it used to be an owner had to give this written notice of any claim for liquidated damages, but the AIA has specifically excluded that. So as contractor, keep that in mind. You're not entitled to any written notice of a claim for LDs from the owner like you used to be. If we go to the next slide.
This person.
So you have to give the written notice. So how do you do that? Well, the general notice section in the AIA is in section 1.6.1. And pretty straightforward. It says you can give notice by mail, courier, email, or another method in the agreement. But if you look at 1.6.2, it specifically addresses these notice of claims we just discussed in Article 15. It says the writing is only deemed served if you deliver it to for example, the architect by certified or registered mail, or by courier providing proof of delivery. Seems over the top to me. I don't know what a court would say if you emailed a notice to everybody, they got it, but you didn't do it by certified or registered mail. I know when there's statutes out there that require service by a specific method, such as certified, and you don't do that, that can be fatal to a claim. I don't know if that's the same result based on a contract provision like this. But the lesson is here, make sure you comply, because you don't want to give someone or the other side of any argument that your claim is invalid. But I would suspect that courts would probably be hard pressed to kick out a claim if there's no dispute it was received by email or otherwise by an owner and architect, it wasn't certified or registered mail. But who knows? If we go to the next slide, and again, these deadlines are important. There's court cases around the country that have these similar provisions where the courts have kicked out an otherwise valid claim because the required written claim notice was not given by that 21-day deadline. So make sure you comply with that. And I think finally the last slide is follow all of the contractual claims related procedures, deadlines, and other requirements. So make sure you read them, comply with them, get the staff in your office, your contractors, to understand these provisions. And when something happens, whether something is found on the project, unforeseen condition, and you think you're entitled to extra time or money, shoot off an email or I guess certified mail notice to the owner and architect saying, hey, I'm giving you notice that the situation came up. We're making a claim for extra money and time on this. You might not know the amount, but at least you're going to give them notice that, hey, you're going to seek that. And then as you progress with the project and the amounts of time or money become firm, you can supplement that notice with the amounts in the backup. So anyway, well, I think that is all the time we have. And hopefully this has been helpful. Ariel, thank you. And thanks to everybody who attended.
Thank you so much. That was definitely a voluminous amount of very helpful information. And if anyone has any questions, feel free to ask now, and we'll just take a minute to wait. But if you don't have any questions or you think of a question, we highly recommend Stephen and his law firm. They're a great firm, and he's exceptionally clearly well-versed in construction lien law. So again, great job, Stephen.
Thank you.
And at the moment, we don't have any questions. But again, if you have any questions, feel free to reach out to us at any time. And we have 2 webinars coming up on mechanics liens on May 10th, and our next one is on lien waivers and releases on August 9th. I know that's like a real stickler for a lot of people, so I'm looking forward to that one. And with that, I want to again thank you so much for such a great webinar, and I wish everyone a sunny day.
Thank you.